is dealing with a very new, complex, and emotional issue. How to balance the expectations of privacy and equality in one of the most private areas of our lives: restrooms, locker rooms, or public shower facilities. This was not a North Carolina state agenda. No one in North Carolina was talking about bathroom policy until the Charlotte City Council imposed a mandate on private businesses. This mandate required, with potential penalty of fine, access to restrooms, locker rooms, or shower facilities be based upon one's gender identity or gender expression. A similar policy was rejected just months earlier by the voters of Houston, Texas, by 61% of the vote. This caused major privacy concerns about males entering female facilities or females entering male facilities. Our state legislature believed this was an unnecessary government overreach into the private sector, imposing regulations and impacting one's personal privacy. The state legislature and this governor also believed that guidelines then needed to be put in place because of this new public topic for government buildings, our schools, and our rest stops to ensure privacy and expectation privacy for everyone. Now, just 5 days ago, the U.S. Department of Justice sent letters to my office, the Department of Public Safety, which reports to this governor, and to the university system, suggesting that having government employees use the bathroom, locker room, or shower facility that corresponds to their biological sex is in conflict with federal policy. The Department of Justice asked all parties to set aside their constitutional duty and refuse to follow or enforce our state law. This was a substantial request with very serious implications, and the U.S. government gave us a mere 3 business days to respond to this letter. We asked on Friday the Department of Justice for additional time. In fact, we asked for an additional 2 weeks, but they refused unless I made a statement where I would publicly agree with their interpretation of federal law, and if I did, they would give me 1 additional week to respond. I could not agree to that because I do not agree with their interpretation of federal law. That is why this morning I have asked a federal court to clarify what the law actually is. Now, I anticipate our own legislature, other private sector entities from throughout the United States, and possibly other states to join us in seeking this clarification, because this is not just a North Carolina issue. This is now a national issue, and an issue which imposes new law on every private sector employer throughout the United States of America with over 15 employees. We believe a court, rather than a federal agency, should tell our state, our nation, and employers across the country what the law requires. And let me say something. Our nation is one nation, especially when it comes to fighting discrimination, which I support wholeheartedly. Ultimately, I think it's time for the U.S. Congress to bring clarity to our national anti-discrimination provisions under Title VII and Title IX. Let me repeat that one more time to all of our U.S. representatives and the leaders of both the Republican and Democratic parties in Congress. Ultimately, I think it's time for the U.S. Congress to bring clarity to our national anti-discrimination provisions under Title VII and Title IX. Now, right now, the Obama administration is bypassing Congress by attempting to rewrite the law and set basic restroom policies, locker room policies, and even shower policies for public and private employers across the country, not just North Carolina. Now, I'm still asking the North Carolina legislature to reinstate the ability to sue for wrongful termination for discrimination in state court. I encourage them to do this and do it quickly. I also welcome additional dialogue with the city of Charlotte and our state legislature, which has been ongoing for the past week. And I want to ensure the people of our state and our country that North Carolina has long held traditions of ensuring equality. The majority of our citizens in our great state and this governor did not seek out this issue. However, the state of North Carolina and this governor welcome the opportunity to be part of the solution for all of the states and especially our nation, the greatest nation, the United States of America. Thank you very much.
All right, so then we're listening to Governor Pat McCrory and the ongoing controversy over the North Carolina bathroom bill. As he was pointing out, the Department of Justice wanted him to agree with their interpretation of federal law. He also gave the outline of time, 3 business days for him to do so. And now in the mix is the funding that North Carolina's education, the state, will get or may not get because of what HB2, the law that went into effect in North Carolina in the spring, means. So there's this legal battle going back and forth. The state has now pushed back to the Department of Justice, saying that their filing on the grounds of the Civil Rights Act is not appropriate for what they're doing. MSNBC chief legal correspondent Ari Melber joins me now. And Ari, let's talk about the interpretation of federal law, because it was just in April that the Fourth Circuit ruled on a case in Virginia. The Fourth Circuit also oversees North Carolina. So isn't there legal standing from a DOJ perspective on what this bathroom bill means?
There absolutely is, according to that decision. I mean, I would say the headline coming out of the press conference here is North Carolina is doubling down on its approach here. This was, of course, as you've reported, something that got to a climax because of the Justice Department pushing explicitly on North Carolina. To be clear for folks who are catching up with this whole debate, this has been the Obama DOJ's position for some time, dating back to 2014, when Eric Holder, of course, Loretta Lynch's predecessor, basically said, bottom line, the federal government wants to treat people who are transgender as a protected class. That basically means that they get the triggering of all the protections we associate with other, shall we say, historically or traditionally protected classes of race, of gender, of national origin. That now applies here in the transgender context. The other big thing in terms of sort of fact-checking what we heard just now is, I think what we're hearing from Governor McCrory is a narrative or a story where he was only responding to local developments in his state and a local ordinance that he disagreed with regard to whether people should be protected in this way or not. I think it would be fair to point out, of course, that these types of proposals have been introduced in many states, often in direct reaction to the Supreme Court ruling upholding same-sex marriage, and by some detractors seen as a direct attempt to sort of find a political winning issue around the bathrooms or around what some folks would call a criticism of the line of law that does have those LGBT or transgender as well protections. So that's up for debate, obviously. But I think that's the headline. As you say, there is recent federal precedent that sides with the Obama administration providing these protections.
All right, Melber, all right, thanks so much. Stand by for me. I'm going to go back to NBC's Janet Shamlian on the ground there in North Carolina. And Janet, you were listening to this and a few points you wanted to make.
Well, Ari was talking about precedent, and I think it's important to note there's no recent legal precedent where the federal government threatened a state and said, we're going to take away your money because you are not or are enacting a law that we don't disagree with. You have to go back to Brown versus the Board of Education in the 1950s, when the southern states were not willing to desegregate, for that type of action to happen, where they were threatening them that we're going to take away your money if you don't desegregate the schools. It has been half a century since we've seen the federal government step in and threaten the funds in this way. It's significant.
It's a tremendous amount of leverage that the federal government is using to get North Carolina to capitulate. Chase, let me bring you back into the conversation, and especially when it comes to what a lot of people are confusing with this bill and the stranger danger aspect of this. And if you identify as transgender, it is a gender identity. It's not a sexualization issue or any type of disorder that I think that there is a fear being stoked within North Carolina. So as we all learn as a country and continue to learn as a country, just explain the difference for folks between gender identity and sexual identity.
Well, I mean, I think the critical thing to understand here is when we're talking about these laws, including the ordinance in Charlotte, we're not talking about getting rid of gendered bathrooms altogether. What we're saying is transgender women who are women are allowed to go to the women's bathroom. And this is, Charlotte, all Charlotte did was say that you can't discriminate against people because they're gay or transgender. And then the North Carolina legislature passed a sweeping law that essentially mandates discrimination against transgender people. And a transgender person is just another person who has a gender identity that may differ from the sex they were assigned at birth, and it doesn't have anything to do with what they're going to do in the bathroom. All they're going to do in the bathroom is go to the bathroom. And what we know from experience is that prohibiting discrimination against transgender people does not increase public safety incidents, has never led to some sort of foul play in the bathroom because you decided as a government to protect transgender people. And this is a myth and a lie that's being perpetuated to stoke fears and confusion.
Chase, stand by for me. Josh Earnest at the White House briefing is talking about the North Carolina law right now. Let's dip in.
The business community, that what the North Carolina government has done is inconsistent with the best interests of the people of North Carolina and the economy of North Carolina. That obviously will be something that North Carolina officials will have to deal with. But there's been a reluctance on the part of businesses that had previously committed to expanding the amount of business that they do in North Carolina from engaging with a government that just makes it easier to discriminate against their employees and potential customers.
What are the ramifications of Iran test firing another ballistic missile?
Dr. Is there a comment about the North Carolina bathroom law? I want to go to our Jonathan Capehart. And Jonathan, one thing that has come out of the conversations for all of this, and I think a lot of heavy emphasis, is the fact that transgender Americans are being demonized as some type of predator. And that's the onus that's being used here. That's the catalyst that's being used to move something like this forward.
Right. The governor mentioned the Houston bill that actually passed. And if you remember, the campaign around that Houston so-called bathroom bill got so ugly that there was an ad for the so-called bathroom law that ran on the air that was so disturbing and so wrong on so many levels that it played into the fear that there are just people out there men specifically out there who are just waiting for this law to pass so that they can use that as an excuse to go into the women's room and prey on women and little girls, as was shown in that ad. And as I mentioned, that law did pass. But I found it interesting that Governor McCrory mentioned that. He also said that this was a battle or a conversation that the state of North Carolina didn't seek out. And he also talked about how he complained how the federal government would not grant them an extension of 2 weeks that they were seeking unless they admitted that they agreed with the federal government. And I bring that timing up because if you also recall that the state legislature, both houses of the state legislature and the governor, debated and passed this North Carolina law in less than 24 hours. So if they had enough time to pass that law at breakneck speed, they certainly should have enough time to answer the government's lawsuit.
And again, as Janet Chamberlain pointed out, this is a pretty fast and swift request from the government to move so quickly, holding up that state's federal funding for education. Jonathan Capehart, thanks so much. Chase Trangio from the ACLU, thank you. And of course, our Ari Melber. We've got some new moves to talk about on the political front here on the